On Law Weekly today, some senior lawyers share their opinions on the growing trend of allegations of bias made against judicial officers, especially in criminal cases. We also have a recap of the top legal stories. On our interview segment, we chat with the former president of the Commonwealth Lawyers Association, Boma Ozobia. Boma is passionate about judicial reforms and replicating global standards here in Nigeria. In this interview, we talk about the funding of the judiciary, the anti-corruption war of the federal government, and much more. All that and more on this episode of Law Weekly. Hello and welcome to the program. I am Shola Shoyeli. 2 weeks ago, the National Publicity Secretary of the People's Democratic Party, PDP, Olisa Metu, who is being tried by the Economic and Financial Crimes Commission for allegedly laundering about 400 million naira, accused trial judge Justice Okun Abang of bias. The allegation was made after the EFCC had called 8 witnesses and closed its case against Mr. Metu. Justice Abang had dismissed a no-case submission made by Metu and asked him to open his defense. But Mr. Metu, in his petition to the Chief Judge, Justice Ibrahim Alta, expressed the fear that he might never get justice because Justice Abang was his classmate in the law school. The judge was also accused of deliberately withholding the records of court proceedings from the defense team, a move which they say prevented them from appealing against some of the decisions made against them in the course of trial. Justice Abang has, however, decided to proceed with the case, pending the decision of the CJ on the issue. If Justice Alta finds merit in Metu's petition, his case will be reassigned to another judge and the matter will start afresh. A former Niger Delta militant leader, Govt Ekpemopolo, popularly known as Tompolo, who was charged along with 9 others on a 40-count charge of alleged 45.9 billion naira fraud, also took the same route. 2 weeks ago, he also wrote a petition against presiding Justice Ibrahim Buba of the Federal High Court in Lagos. Justice Buba had on February 8 refused his application seeking to vacate the warrant of arrest issued against him for his failure to appear in court to take his plea. Through his lawyers, Tompolo claimed that he was afraid he would not get justice before the court. He also asked the CJ to withdraw his case from Justice Buba and reassign it to another judge. Last month, specifically on the 9th of March, the leader of the indigenous people of Biafra, Nnamdi Kanu, and 2 other accused persons who were facing charges of treasonable felony and unlawful possession of firearms accused Justice Soho of bias. The 3 men said they had no confidence in the impartiality of the judge, so they sought an order directing the Chief Judge of the Federal High Court to reassign their case to another judge. The allegation was made on the heels of a ruling by the judge granting an application by the prosecution to shield its witnesses. In December last year, Nnamdi Kanu had rejected another judge, Justice Ahmed Mohammed, to whom the case was originally assigned, also on the grounds of lack of confidence in the court. All these cases and more suggest that there is a new trend of leveling allegations of bias against judges. It has proven worrisome for stakeholders after yet another judge, Justice Abdul Kafarati of a Federal High Court in Abuja, disqualified himself from a case on the very day that he was meant to deliver judgment. The judge, who said he was caught between 2 devils, hinged his decision to withdraw from the Senate President's case after a publication by an online medium which he said had impugned his integrity as a judge and portrayed him as having been compromised. The consequence of this is that the case will start all over again. Some lawyers are worried about this rising trend, and a few of them spoke to Law Weekly.
There are ways of going about this bias. You go to the Nigerian Judicial Council, you go with your evidence, and you say, this is what has happened. This is proof that this judge is biased. What you don't do is just point fingers to judges in courts or outside courts and accuse them of bias or write bogus petitions in order to drive the judge away and then have the judge substituted. Because if you allow this to be the norm, what happens? Every judge that is brought in for that case will be simply accused of bias, and that will be the end of it. So the matter will be delayed for years on end. No, the matter must be judged. Even if the issue of bias should be treated later on, let's first judge the substantive issue against you. You have been accused of maybe a serious crime. Answer to those crimes, and then let us talk about the issue of bias afterwards.
I'm of the view that even the mere fact that somebody is somebody's classmate is not enough reason for the person to, disqualify himself from going on with the case. I've seen a judge who sentenced his classmate to a term of imprisonment, despite the fact that they were classmates in the University of Ife. So it serves as an example of a spurious allegation. But in Kafarati's case, I think the position is that I believe it was too early. It was too early for him to have handed over the matter, answered from that matter, because the mere fact that somebody makes any allegation and says anything is not enough. That should be in a hurry to now say that you want to hand over the file or you want to divest yourself of trying the matter. So unless if the person has evidence and facts, he can apply to the chief judge, back it up with evidence. Then if the chief judge realizes that there is merit in such application, then he can now ask the judge to hand over the file to another judge.
I think it has gotten to a stage whereby our law needs to be amended, and that for every allegation you make, you must be able to substantiate it. And if it's not substantiated, then you must be able to adequately be punished for it. You understand? Now you are accused of a criminal allegation. Instead of you machining your defense and what have you, you are cooking up a story, quote and unquote, cooking up a story that someone is biased. Let that allegation of bias be substantiated. Otherwise, the case should go on. And I want to employ judges. And I want to encourage them to please be focused, to please be confident, to please be bold enough. Not every allegation of bias that they should cave into. Once your conscience is clear that you are not biased, please, you can distinguish it and go ahead with your case.
Away from that issue, let's take a look now at some of the top legal stories in the news.
We begin with the Bayelsa State Governorship Elections Petition Tribunal, which has fixed April the 11th to give ruling on whether to allow the governorship candidate of the All Progressives Congress in the Bayelsa State governorship elections, Mr. Timothy Silva, inspect the election materials used for the December 5th, 2015 and January 2016 elections. Mr. Silva had filed the application seeking an order to compel the chairman of the Independent National Electoral Commission to allow him inspect the electoral materials used for the polls. The 37 items sought to be inspected includes used ballot papers, thumb-printed and counted as valid in the election, ballot papers recorded as invalid, ballot papers recorded as unused, and printouts of records of accreditation as captured by the smart card reader.
People were interviewed, they were given jobs.
In Osun State, a legal practitioner, Komi Ajibola, has instituted a legal action at the State High Court against the government to seek a stay of action of the planned sack of about 678 staff of the Ladoke Akintola University Teaching Hospital, Lautech, in Osogbo, the state capital. The lawyer says that the claim that there is over-recruitment at the hospital is suspicious. The former Attorney General and Commissioner of Justice in the state, Mr. Wale Afolabi, however, believes that the suit instituted by Mr. Ajibola is not valid because the litigant is neither a staff nor a student of the hospital. He hinted that a defense against the suit is already being prepared by the State Ministry of Justice. Mr. Afolabi also says that the government, being the employer of the staff, has a right to investigate any wrong action taken in the process of recruiting them. Meanwhile, a date is yet to be given for the hearing of the suit. And the body of Senior Advocate of Nigeria rose from its meeting with a call on lawyers to desist from the habit of making disparaging remarks against judges. The body warns that the habit is not only unprofessional, but will also ultimately undermine the integrity of the judiciary. It also says it is unfair and discouraging for honest and hard-working judges in the country to be painted with the same brush as the few who have been found wanting for misconduct. The body also declared its support for the federal government's anti-corruption war, but warned the federal government and agencies to ensure that its anti-corruption battle is fought within the ambit of the rule of law, devoid of abuse of the fundamental rights of Nigerians. And we round off in South Africa, where the Apex Court has ordered President Jacob Zuma to repay a yet-to-be-determined amount used for the non-security upgrades of his country home in Nkandla in KwaZulu-Natal. The upgrades, which cost 246 million rands, that's about 3.3 billion naira, has sparked controversy that has lingered for about 3 years. Reading the unanimous decision of 11 justices of the Constitutional Court, the Chief Justice, Mogoeng, ruled that President Jacob Zuma failed to uphold the Constitution by ignoring the remedial actions recommended by the public prosecutor. He also ruled that the National Assembly failed in its oversight obligations to hold the executive arm of government to account.
You may proceed, Mr. Turnbull.
Thank you, Chief Justice.